It's fantastic to see so many of you here. It's really heartening. So just welcome everybody. I'm Kath Dyson, and I'm one of the coordinators in Women's Rights Network Manchester. And Mary Curran and I, who's here, Mary's here, put on this event with Jan McVarish of FSU. So firstly, just thank you very much to the FSU for partnering with us on this event. So thank you. Don't know, Jan's back there. Thank you. Just want to introduce firstly Jo Bartosch. She'll be interviewing Akua. She's a widely published journalist who's had bylines in the UK's leading publications, including The Times, Telegraph and Mail on Sunday. She's an assistant editor of The Critic and a regular contributor of Spiked. She was one of the first British journalists to write for mainstream publications about the dangers of childhood transition and was at the forefront of investigations into Stonewall and mermaids. She's also the memo editor for Sex Matters, and she's got her first book published within the next 6 months. Is that right, Jo? In October this year, Pornocracy. And Akua, to introduce Akua Reindorf KC is one of the most authoritative legal voices working in equality law today. She's been a key figure in the debates around sex and gender and freedom of speech. She's been involved in some of the critical investigatory and litigation activity in these areas, as well as being written and speaking widely on them. She successfully defended the LGBT Alliance, acted on behalf of people and groups such as James Essex, Julie Bindel and Sex Matters. She wrote and gave her name to the University of Essex's Reindorf report into allegations of no platforming of 2 external speakers who were accused of transphobia. The report was hailed as a turning point in the debate around sex and gender, trans rights and cancel culture in universities. She's also the visiting senior lecturer at LSE Law School and a commissioner for the EHRC, but she's appearing here in a private capacity. So if you could put your hands together and give a huge welcome to both Akua and Jo.
So thank you all for being here, and how exciting that we didn't have to push past a crowd of protesters. That feels like a sea change. So I'm going to get stuck right in, if I may, and so as was mentioned last month, the Supreme Court ruled that sex is biological in the Equality Act, and that's been met with some. I think a tantrum, really. I was wondering if you could perhaps answer some of the queries that have been put and some of the misinformation. I was wondering if you could put some of the myths to bed about what the ruling actually says. And I suppose first up amongst those is... I have seen it all over the place, from Reddit to even to Parliament, that butch lesbians are apparently now going to be challenged in single-sex spaces, particularly toilets. Do you think that's more likely to happen now as a result of the ruling?
Let me just check. Oh, that is working. Thank you, Jo, and thank you, everybody, for coming. I'm quite alarmed to see how many people have come, if I'm completely honest. Butch lesbians being challenged. Well, I mean, far be it from me to engage in anecdote from the off, but I have been challenged in single-sex spaces and other spaces and misgendered since I was 4 years old. At one point, when I was 8 months pregnant and in the haberdashery department of John Lewis, asking where the knitting needles were, and the man said, "They're over there, sir," and I said, "I'm 8 months pregnant." And he said, "Oh, sorry." But it happens to me literally weekly. I'm still alive. I haven't keeled over yet. I have not found it has happened more frequently since this issue has become, salient in society. And I think I don't really see any particular reason why it should become more prevalent from now on. And even if it does, it's not a reason to abandon single-sex spaces. Really, I think that's really all there is to say about it. I mean, it's not great, it's not ideal, I don't enjoy it, but at the same time, it's not a mortal wound.
And one of the other points that seems to be doing the rounds is that women who have undergone treatments to look like men will alarm other women if they're placed on, for example, female hospital wards. And that if this becomes normal, then predatory men will exploit this. Do you foresee that happening?
I mean, I find this argument quite extraordinary. These are the people who, for years, have argued that men will not pretend to be trans women in order to access women's spaces. But now it seems that men will pretend to be trans men in order to access female spaces, which, I just don't see the logic of it at all. It just seems an incredible stretch to me. I mean, yes, of course, there may well be some issues along these lines. We know that predatory men are capable of virtually anything. But again, it's not a reason to abandon the idea of women's safety, dignity and privacy altogether. It just needs to be properly operationalised in the same way that it has been for decades prior to the last 10 or 15 years by way of, the social contract that we have and people having rules and, essentially most of us, all of us can recognise almost all males and females and distinguish them from each other. So really, again, I think that's a red herring.
Thank you. And finally, I think a lot of organisations seem to believe that both the Supreme Court clarification on the law and indeed the EHRC guidance, the interim guidance that was written, isn't statutory and that it can just be ignored. Could you please perhaps sort of explain whether this is the case, what they do actually have to do, and whether they have to wait for more guidance to be published before just getting on with it?
Right. Well, as you can imagine, I eat, sleep and have nightmares about this at the moment and have done for 6 weeks. The first thing to say is it's not interim guidance, it's an interim update. So it was essentially a statement just setting out some of the consequences of the judgment. It is not statutory and it's not binding, but at the same time, the Code of Practice, which is currently being consulted on and which is a statutory Code of Practice, is also not binding because it's not law in the same way that a judgment is law or a statute is law. So the interim statement, the interim update is intended to assist people in how to put into practice the principles which were established in the judgment, as well as the principles which were established actually long before the judgment, which is another point which I might bore on about a bit later. But nobody has to follow it. It's just that if they act unlawfully, then they will find themselves potentially at the wrong end of a county court or employment tribunal action. On the Code of Practice, which is due to be, the consultation is due to end at the end of next month, and then it has to be laid in Parliament, and it becomes the Secretary of State's responsibility to get it over the line. That is not statutory, though. I mean, it's not law. It is statutory, but it's not law. So the way it works is that courts and tribunals have to take it into account when they are deciding a relevant matter, something to which it relates, but they don't have to follow it. And so, by extension, service providers don't have to follow it either. It's just guidance to help you navigate the law. What has to be followed is the law. And that has been established now beyond any doubt in the Supreme Court judgment. But I'm going to bore on about this point now because it always annoys me. The question of whether self-ID it was ever the law or should ever have been the way in which service providers and employers organised their facilities was settled a long time ago. That was settled in 4 Women Scotland 1 at the latest, which was in 2022. But in fact, it was always known, perfectly well understood amongst legal professionals, or at least those who were paying attention, that self-ID was not a lawful basis on which to offer your facilities. and that was accepted in the Supreme Court hearing by the Scottish Government and by Amnesty, who were the parties on the other side to For Women Scotland. And the whole point of the dispute in this For Women Scotland case was that people with GRCs, gender recognition certificates, shouldn't be treated differently to those without. The premise being that people without GRCs did not have any presumptive right to identify into the services and facilities of the opposite biological sex, whereas people with GRCs, on the understanding of the law as it stood at the time, did have that presumptive right, although they could still be excluded under a separate part of the Act. And what the Supreme Court found, the absolute core of their reasoning, was that having that different regime for people with and people without GRCs rendered the Act unworkable. So it was, absolutely at the core of the judgment that there was never any self-ID. But the response to the judgment has been completely wild, in the sense that people have approached it as though it is the judgment which tells us that you can no longer operate according to self-ID policies, which is why I think all this, flailing around and waving of arms and talking about waiting for EHRC guidance has happened. It's not really all that should have to happen at this stage, post For Women Scotland, is that the 9,000 people with GRCs should be being accommodated in accordance with the way that the trans people without GRCs should already be being accommodated, which is in accordance with their biological sex, with whatever adjustments are appropriate in order to prevent discrimination against them. So it's extraordinary, but it's been like a dam breaking, and it's fine. I mean, if it means that people in society, service providers, employers, and importantly lawyers, who seem to be a bit on the back foot as a class, finally understand that self-ID isn't the law, then that's all to the good. But it's very late in the day for them to be catching up.
Thank you. And I know that one of the first pieces of work that I was aware of that you've done, that you wrote in this area, or the sort of research that you've done into this, was the Reindorf Review of 2019. And I believe that followed Essex University no platforming professors Jo Phoenix and Rosa Friedman. Could you perhaps tell us a bit about what you discovered? Because I think it's quite a nice sort of case study of institutional capture, really.
Yeah, it was a really interesting piece of work, because before that I hadn't been involved in sex and gender work at all, although I had lurked on Twitter for a good couple of years and seen what was going on and thought I will never, ever speak on this issue. And yeah, now here we are. But it was fascinating, and it was Jo Phoenix and Rosa Friedman, who were both external speakers at Essex and both suffered from sort of no platforming attempts in one way or another. I can't obviously go into the facts because the bit of the report that's been published has got quite a lot of redactions. But the bit that I was very surprised at how much it took off, the report, when it was published. I was out for a walk, I remember that morning, and I came back and opened Twitter, and I was just like, oh my goodness, it's all gone completely mad. But the bit that really had some salience was the comment that I made about Stonewall, where I'd looked at their internal policies at Essex University and concluded that they reflected the law as Stonewall would prefer it to be, rather than the law as it is, which interestingly was the one bit of the report that had been picked up by the libel reader who had checked the report before publication, but she let it go on the basis it was truthful. So that was really interesting, looking at those internal trans policies at the university, and I've seen many such policies since, largely speaking in universities, which state a version of the law which behaves as though self-ID is the law quite clearly, and has encouraged universities to act in that manner and allow people, both students and staff, to use facilities and services according to their gender identity rather than their sex, and essentially outlaw on pain of excommunication anything like outing or misgendering at all, and are very unbalanced policies and don't reflect the reality of what would be likely to happen if you were to end up in front of a court of law, as we have seen with all the cases that have now been decided in favour of gender-critical claimants, very, very much to the surprise of the respondents in those cases who had been led to believe that they were doing God's work in defending themselves. But just extraordinary, the sort of cognitive dissonance that there has been, and that those institutions very largely who have those sorts of policies, it's very entrenched, and they've been given training and from external providers and been sort of marked by Stonewall on an annual basis, and have been genuinely persuaded that these things are the law, and have been somehow persuaded not to ask anybody else what they think.
So I understand, obviously, there's effectively been a campaigning via stealth, via policy, via HR in a way, through the trainings be offered by groups like Stonewall. Does it apply to other protected characteristics as well? Is it something that perhaps sort of is critical race theory, a similar problem in your opinion, or is it something that is purely related to sex and gender?
I mean, it is largely sex and gender, but I have come across a similar sort of approach in relation to race issues. Yes, where people have been to external training and been taught about microaggressions, and then come back into the institution and caused quite a lot of trouble, because again, that sort of set of ideas really doesn't cohere with what the Equality Act does in relation to discrimination, and the sort of emphasis on lived experience and personal subjective experience of being slighted in a way that you perceive to be related to your race or your gender identity or whatever it is. It just simply cannot found a sensible claim under the Equality Act, and yet we see a lot of institutions behaving as though it does, and then they get themselves into considerable difficulty over those sorts of things. So I think, yes, it is a more systemic issue, but sex and gender is absolutely the foremost area in which this is occurring. And I think, because it has the most powerful lobby groups who drive it forward, and who have completely captured the higher education sector. And the higher education sector is really ground zero for all of this.
Thank you. So I've heard it said that the reason that these policies and these training sort of modules have taken off and have been able to embed themselves is because organisations are basically actually, in a weird sort of way, trying to comply with the Equality Act. Do you think, and I've seen it said as well, and there seems to be a growing move now to scrap the Equality Act in its entirety, and also the Gender Recognition Act. Do you think that's a good idea? And what do you think might the results might be if that were to happen?
Well, I'll start with the Gender Recognition Act. It's a strange piece of legislation. I think we can all agree on that. But also, in a strange way, without it, we wouldn't be where we are now post For Women Scotland, because what's happened in other jurisdictions, in other countries, is that instead of having a separate statutory regime to deal with gender reassignment, it's all lumped into sex. So in our legislative framework, we have the Gender Recognition Act, which allows people to certify their change of gender. And then in the Equality Act, kind of following that in a way, we have a separate protected characteristic of gender reassignment to the protected characteristic of sex. And it has to be separate, partly because of the Gender Recognition Act. for boring reasons. But in other places, gender reassignment just becomes part of sex. So you have sex discrimination, which is essentially gender identity discrimination. Oh, that's what it's been turned into. So being discriminated against because you're a woman becomes being discriminated against because you perform some sort of womanhood, or however you want to define how gender identity works. And that is very, very messy. And once you've knitted the two protected characteristics together in that way, it's like making an omelette. You can't take it apart and separate the eggs out. So in that sense, the Gender Recognition Act is actually pretty useful because it keeps concepts which are mutually incompatible apart. And we now have a very clear statutory framework. Well, I say very clear, relatively clear, clear to those of us who spend our days and nights thinking about it. But it's workable. And it means that we still have sex discrimination, whereas we might not still have sex discrimination if we didn't, a law against sex discrimination, if we didn't have the Gender Recognition Act. And, the Gender Recognition Act now really is about what I think it probably intended to be about at the time that it was passed, which is about people's personal rights which don't impact on other people. So it means that a person can change their birth certificate, then get married as a person of the opposite sex, or be buried as a person of the opposite sex. Now, there may well be arguments about how that impacts on society, but it's not the same. It doesn't have the same impact on society as somebody becoming the opposite sex for the purposes of discrimination law, which does have an enormous impact and means that, as we know, it makes a nonsense of single-sex provision. But it's now been, the GRA has now been sort of siloed back into those private legal rights in a way which I think means that I don't see a particular justification for repealing it, and repealing it would be an enormous, enormous job and would open up an extraordinary can of worms because it does come from a European case law. We were required to do it, to enact it because of European case law. And if anybody were to try to repeal it, we would be straight back into Europe arguing about it, or the European Court of Human Rights arguing about it in a very, very hostile environment in the European Court of Human Rights. And we may very well, whoever was arguing for it might very well get quite a lot more than they bargained for. So I'm not concerned about the GRA. I certainly don't want to see the Equality Act repealed, not least because I'd be out of a job if it was. But I think that I can see what the arguments are for it, and I can see people have concerns about having 9 separate protected characteristics and not others. But the protected characteristics haven't changed at all in 20 years. There was a little flurry of new ones over the turn of the millennium, but then they've remained stable. We've got more under the rubric of protected belief. We've now got a sort of proliferation of subcategories there. Those have been fun for lawyers. And I think the notable exception is class from the protected characteristics, and that's always been a notable exception. There is within the Equality Act a socio-economic duty which recognises a category of class, but it hasn't been brought into effect in England, only in Wales and Scotland. And anyway, it's not really a protected characteristic, it's just a duty to have regard to socio-economic factors in the same way that one does when under the public sector equality duty have regard to the other protected characteristics. So I think that as a ground on which people experience discrimination in society, that is a big exception, because it's obviously at the heart, like an old lefty like me is always going to say this, but it's obviously at the heart of quite a lot of discrimination that occurs. In fact, I would say the vast majority of it. But I think really the real problem with the way that the Equality Act operates these days is the way it comes up against what we might call broadly, excuse me, identity politics, which, as I said earlier, has a very different conception of things like harm and discrimination than the actual Equality Act does. The Equality Act has, at every level, objective tests for whether somebody's been harmed, subjected to a detriment, treated less favourably, and so on. It never relies only on subjective perception. But the way in which a lot of particularly young people are now thinking about equality, diversity, inclusion is not aligned with that model, with that sort of framework of analysis at all. So I personally don't think it's the Equality Act that's at fault. Obviously, it could be tinkered with. I think it's identity politics that's at fault.
Okay,
really.
thanks. I mean, you mentioned there that there are sort of obviously subcategories of belief, and that it's created work for lawyers. I mean, do you think essentially things like the Fastata ruling, which obviously protected gender critical beliefs, do you think there's a concern now that we might just end up with more and more subcategories, whereas actually that's a kind of sticking plaster for what is a crisis in freedom of speech, in democracy, in the sort of values that we want depended upon?
Well, I mean, law is always going to be a sticking plaster because it's always after the fact. So, I welcome Fastata. I thought it was an inspired idea of Anya Palmer's to argue it in the way that she did. I think it has been an extremely productive bit of law which has made an enormous difference to a lot of people's day-to-day lives in a really positive way. I think I can see why people argue that it's pointless because believing that sex is real isn't a belief; it's a fact. But the reality is that that's not actually the core of what the belief is for the purposes of Fastata. The core of it is the sex is important bit. The belief, as fully expressed, is that sex is real, immutable, and important, and that's the bit, the important bit. And essentially that it should be the organising principle rather than gender identity, and that is a belief. I mean, and there's an opposite belief, which is that gender identity should be the organising principle, and people have not yet brought claims on the basis of that belief. It would be interesting to see what would happen if they did, but it was sort of conceded in Fastata that would be a protected belief. But we'll see. Somebody may one day bring a claim on that basis. The tide is turning now, so it may happen. But I don't see Fastata as having been a sticking plaster, other than to the extent to which the law is always a sticking plaster. So it's a place of last resort. But it also can be a shield. You can use it for in your day-to-day life to threaten people with, essentially. So that doesn't make it a shield; it makes it a weapon. But you get the picture. In terms of the protected characteristic of belief, yes, there's a lot of argument about whether we're just going to get hundreds and hundreds of weird protected beliefs, like ethical veganism is one, and climate change, and there are lots of different ones. But yeah, I mean, it's clunky. But it is a way in which free speech principles are embedded, is one of the ways in which free speech principles from the European Convention on Human Rights are embedded into our day-to-day law, the law that we use day-to-day, not the Human Rights Act, which imports that principle generally, but directly into the lifeblood of our sort of more workaday law, like the Equality Act, which really is for people's day-to-day lives, and which you can rely on directly in a tribunal, whereas the Human Rights Act is always floating around in the background, but is very rarely something that you can actually invoke directly. So, it's clunky, but I think it does a job of work which is necessary, and if we didn't have it, my life would be less interesting.
Okay, so you don't think... So I appreciate your point that it's something that's that happened after the fact, but you don't think that the increase in instances of people needing to rely on this is symptomatic of a crisis, of a broader crisis of freedom of speech. And I just wondered if you thought that was something that perhaps it is indicative of, and if perhaps you had any thoughts about the fact that obviously freedom of speech used to be thought of as something that was very much a left-wing value, and now it's considered to be almost a sort of right-wing dog whistle, which is, I think, quite bizarre. And I just wondered sort of more broadly outside of the law, I suppose, whether you had any thoughts about that.
Yeah, well, there's a lot there. I think I'll go backwards and see if I can remember. So in terms of whether the free speech is a left or right-wing thing, obviously free speech always used to be thought of as a left-wing value. I think that it is something which is sort of grabbed hold of by whichever political tribe feels that it's in the sort of cultural and intellectual minority at any given point in history, which is why the right feel currently as though it belongs to them, because they feel in, academia, politics, the arts and so forth, that they are marginalised. So I think it'll come back to the left. I mean, I remember a couple of years ago, Owen Jones tried to start a real free speech campaign in relation to Israel and Palestine, which didn't take off. But he with the university and college union, and they did a big splash on Twitter, but nobody liked their tweets. So they took them down. But they were so at pains to distinguish it from, the free speech that gender-critical people ask for, that it really did fall quite flat. But yeah, no, it's not. Free speech is not, it shouldn't be a left-right thing. It should just be a fundamental value. It is a fundamental value. It's the key human rights, and we're not supposed to put human rights in a hierarchy, but free speech really is the sort of linchpin of the European Convention, and there are additional duties in the Human Rights Act relating to free speech which don't relate to other human rights or other convention rights. So I think it will always wax and wane. I do think there is a crisis, and I think that crisis is located principally in higher education. I've been quite shocked by what I've seen in higher education over the last few years. I've got one son at university here in Manchester and one son who did his A-levels last year. And my younger son hasn't gone to university. He's just fighting, literally. He's a jiu-jitsu fighter, and that's all he does all day long. And I'm not at all concerned, actually, that he's not planning immediately to go to university. I'm quite satisfied that he waits, and in the hope that university improves, because it doesn't seem to me to be somewhere where you go to expand your mind anymore, and that is a real shame, a serious shame. And when it starts in universities, which are supposed to be the stronghold of free speech and open inquiry in our society, then that spreads out across the whole of society, and I think that's a very great shame. But I do think it's on the turn. I think that the increase in people relying on protected beliefs under the Equality Act is partly a reflection of the free speech crisis, but it's also partly a reflection of the fact it's turning around, because people are feeling more able to go to law with it and to take that risk. When you're deep in the deepest part of the crisis, nobody dares put their head above the parapet at all. But now people are daring to bring that case and go to tribunal and have their say and feel that they're going to be protected by the judges. And I will say that I have always said the judges will save us. And they have. Because the law, the judges, I will say I am a judge, but I'm not speaking in that capacity. But, the law has a rigour to it which can't really be lost, because it's part of how statute has been built, and principles of statutory interpretation which have developed over many, many years. And it isn't as fickle as academic thought. So while academia can just sort of turn on a sixpence and become something quite unrecognisable, the law just doesn't have that in it. And also the law is really not corrupt. I mean, I know people like to think it is, but judges, generally speaking, in our system are not at all corrupt and won't be swayed by passing fads. So there will be, take their oath and their duty seriously and apply the law to the facts that are before them. And we've seen that time and time again. And I think that is starting to give people confidence that they can seek and obtain a remedy for a wrong in our courts of law.
Thank you. That's slightly sort of introduced the final question I was going to ask, which is about this sort of the debate around sex and gender in particular has really sort of forced me to reevaluate my own beliefs and things that I used to depend on. I think I was rather complacent about freedom of speech. I didn't really see the relevance. Do you think now we might perhaps see a renaissance in interest in critical thinking, in freedom of speech, in all the sort of values that underpin a healthy democracy?
Yeah, I do. I mean, I went out, I took my other son, my older son, and three of his, what I rather stupidly called his little friends, out for lunch today in Manchester, and I was very, very encouraged by the extent to which they still have inquiring minds. They really interested in talking to an old woman like me about all sorts of issues. I mean, these are not kids who are woke. They're just basically beer drinking lads. Just lads at university. Nice, lovely boys. But I was very encouraged, and I think that the younger generation coming up are going to be chomping at the bit for that, because that's the human condition. The human condition is not to just chant slogans and shut your brain down. And the youth will always find a way to question, in particular, the generation immediately above it. And I think that we will have a renaissance. And as I said, I think that things are on the turn already, and it will only get better from here. At least that's my hope.
Oh no, it's nice to be able to sort of end the question section on something so positive. So I think questions are now going to go out to the audience. If anybody
This is the hard bit. Soft soaping ends here.
I would like you, if possible, to say a little bit more about statutory guidance, because I can't quite get. There's the law.
Yeah.
And then the EHRC have to do guidance that will go to Parliament.
Yeah.
But what is it then? What does statutory guidance mean once, assuming it passes in Parliament? What?
Yeah. Well, the way it works is, so the law is in the statute, that's the legislation, and then the case is decided by courts. Obviously, Supreme Court is the supreme law. Cases decided at employment tribunal level or county court level are not binding on anybody. But, as you go up the appeals, they become more important. So that's the law. The EHRC is the regulator of the Equality Act. And the EHRC is empowered under a different Equality Act, the Equality Act 2006, to issue guidance which basically is there to help people to navigate the Equality Act 2010. It isn't itself something that anybody is obliged to follow. It's not rules, whereas the law is rules. So the statute and the case law is rules. The guidance is literally just what it says on the tin. It's codes of practice. And the EHRC doesn't have to issue codes of practice, but they're empowered to do so. But once they are done, so the EHRC drafts up the code of practice, does the consultation and so on, and then hands the finished product over to the Secretary of State, who then goes through a parliamentary procedure, which is, the theory is that with this statutory code of practice, the theory is that it goes through a process that's called laying in Parliament, for 40 days, which is a negative process, which just means it lies there on the books for 40 days, and if any parliamentarian wants to kick up a fuss, they can do it in that 40 days. I think that's probably quite likely in current circumstances, but yeah, I don't think it's happened before in relation to the codes of practice. And then the thing just becomes law at the end of that time. I mean, when I say it becomes law, I mean it becomes official. It's not law, it's just official guidance. And then when a court hears a case, let's say somebody brings a case about single-sex loos in their leisure centre to the county court, that county court judge has to look at the guidance and have regard to it when deciding the case. But if that judge thinks that the guidance is wrong in any respect, they can disregard it. They're not obliged to follow it. I mean, you'd expect them probably to follow it, but they don't. They certainly don't have to. And if they give reasons why they think it's wrong. And to be honest, I don't know why everybody's behaving as if the code of practice is some kind of holy grail. I have been a discrimination lawyer for 25 years, and I could count on the fingers of one hand the times that I've drawn a judge's attention to anything in the code, in either of the codes of practice, because there are two codes of practice. One is for employment and one's for goods and services. Well, it used to be called goods and services, but it's now services, public functions and associations. And they're very out of date apart from anything else. They were both published at the same time that the Equality Act came into force. So they're not that useful. But, I know service providers and so on sometimes look at them, but they're really not the holy grail that they're being made out to be. And one point which I didn't make earlier is that insofar as employers seem to be thinking that they don't have to do anything until the Code of Practice is published, this is nonsense. The Code of Practice is not about employment. It is for services and not employment, and it's a completely different statutory framework. Does that answer your question? Thanks.
Excellent.
Hello. I'm from Thoughtful Therapists, and I wanted to we're in a kind of odd position as therapists. I know you defended James Essex, so it's the whole thing about ethics and harm and law, and we are battling with our professional memberships at the moment, and we would like to try and bring some legal thing. It feels quite complicated, and today, Stella O'Malley has released, I don't know if you've seen it, from GenSpect, something about another memorandum of understanding, because we have the memorandum of understanding about conversion therapy, and she's written this memorandum of understanding about the right of children to have puberty. It's an extremely powerful document, and I wondered, it feels difficult because it's something about harm, and it's about harm and ethics and where the law comes into that. Yeah. And actually, we are harming children by putting them on puberty blockers. We are harming children by telling them we are destabilising them by telling them that they can change sex, and it feels like it should be illegal. So that's where I feel we're a bit caught in that at the moment.
Yeah, no, I understand that. I mean, you're sort of veering into an area of law that's not my specialism, which is outside of discrimination and equality law, although it does obviously touch on that. And the context in which I've come across the Memorandum of Understanding, which is a document which I'm sure most of you are familiar with, which is issued by a sort of trans advocacy outfit some years ago, and the professional membership organisations in psychology, psychotherapy and so on have sort of signed it and taken a vow to obey it. It's a gender affirmation pledge, essentially. I've come across that in the context of, for instance, James Essex's case, where an individual has been disciplined for failing to comply with the Memorandum of Understanding, and that there are very good arguments to be made about that for an individual person working in that field. As you can see by the fact that James managed to settle his case favourably. But in terms of what can be done on the sort of medical ethics side, that is outside my expertise, I'm afraid, but I don't disagree.
Someone here, and then we'll take some from the back. Hi. First of all, I just want to thank you for your kind of positivity, because I found it quite hopeful what you were saying. And I'm sort of going to ask you a bit of a ridiculous question, because it's a bit like asking you to be a psychic. But you're talking about higher education, and that the biggest problems are kind of occurring in there around free speech, and particularly around having gender critical views.
Yeah.
And I'm interested. You know, you were saying that we are in a sort of a turning point, but it felt like a little bit of a like miserableness about where we are in higher education. And I just sort of wanted to ask your thoughts on, can you see this progressing in the next few years? Can you see a shift? Can you see movement in it? From obviously your stance as sort of someone on the legal. Basically, I've got a 15-year-old daughter, and I don't want to go to fucking university. And I'm hoping to God in the next 3 years it'll be different. So just give me some hope.
Yeah. Well, I wish I could. I mean, I don't have that much optimism about higher education moving very quickly, and I think there's a number of factors in higher education. It's not amongst the students, because, as you say, I think that the students are likely to become more and more impatient with, wokeness and identity politics. It's the staff. I think that there's a real toxic mix of marketisation in higher education, insecure, precarious employment at the lower ends of the academic workforce, which means that they're not incentivized or motivated to speak up and speak out and to, push against orthodox thought, and don't have any incentive to do that, to put their jobs at risk, which are already deeply precarious. The marketisation of the sector is a real problem, because it means that, university administrations, they want to endorse their website with Stonewall badge and an Athena Swan badge and an Advanced HE badge and all the rest of it, to attract more and more students in, which is done by obeying these institutions in accordance with how their internal policies should be written and implemented. So I think there is a real toxic mix in the sort of staff group in academia. The only glimmer of hope I can give you is that the students will force that change. So get your daughter onto it.
Thanks very much, Akua and Jo, for that conversation. One of the things that really boiled my blood is around the protected characteristics of sexual orientation, and how that has got how gender ideology has had such a negative impact on lesbians and gay men. Mm-hmm. And in the Supreme Court judgment, I think the lesbian interveners apparently it was an amazing piece of work, which really allowed the judges to understand some of the implications for that group of women. Yeah. And so it's a general question, really, and I'd like both Jo and Akua to say something about it. But I suppose, Akua, from a legal perspective, what was the lesbian interveners' main impact on the judges? And Jo, if you've got anything to say around generally gender ideology and its impact on lesbians and gay men.
Do you want me to go first? Okay. I mean, the lesbian interveners' intervention was really, really brilliant. It was unfortunately, they didn't get permission to make an oral submission, but they did a written submission, which was really excellent. And I mean, the impact of it really was that it brought very starkly to light the fact that, lesbians are not attracted to pieces of paper. That was the main thing. And which I will explain in a moment. And also that, with as J.K. Rowling said long ago, without sex, there's no sexual orientation. And they really, you could see the judges. I was there for the hearing, and you could see the judges' faces as these sort of pennies dropped during the course of the hearing. But the lesbians aren't attracted to pieces of paper actually made it into the judgment, which was amazing. But again, this was about the difference between having a GRC and not having a GRC. This wasn't about self-ID. It was about whether or not a lesbian was a person who is either a woman or a male identifying as a woman who has a GRC, who is attracted to other such people, but not to women who identify as male but have GRCs, and not to males who identify as women but don't have GRCs, because that is what the category of lesbian would be, and similar for gay men, if the law stood as it was previously. And this point was brought to the attention of the court below, which was the inner house of the Court of Session in Scotland, and they sort of poo-pooed it. In fact, it was brought to their attention on the basis of a letter that the EHRC had written to the Secretary of State in 2022 or 23, in which those points were made. And the inner house judge just poo-pooed this idea about being legally lesbian, and then the idea of being legally lesbian became a sort of joke phrase amongst trans activists, which was quite annoying. But it really was a serious problem, and we've seen an enormous deterioration in lesbian social life over recent years, alongside a massive increase in sort of queer social life, which is great, fine for people who are into that. But lesbians, and I'm speaking, really from a personal perspective here, are, concerned about the effect on younger lesbians who are coming out. We see a huge number of young lesbians. We see a huge reduction in butch young lesbians, for one thing, which is incredibly worrying. And we see a huge amount of pressure being brought to bear on younger lesbians to engage sexually with men, which, I kind of have no words really for it. So the lesbian interveners did a fantastically important job, and the Supreme Court did a fantastically important job in making sure that they referred specifically to that in their judgment, and that they made the position very, very clear, and they kind of slapped down the inner house of the Court of Session over that point as well, because it really did, the law as it stood meant that there really wasn't a meaningful category of sexual orientation in the Equality Act, and that has quite far-reaching consequences. And it meant in particular that you couldn't have an association for just lesbians or just gay men without allowing in people of the opposite biological sex who have a certificate. So you now can, which is great. I didn't do it.
So I think, obviously, as you've covered the ruling, I can perhaps sort of talk more generally. So there was a Pride March in a town where I grew up, actually, and they made it very clear. They said they didn't want any LGB views. That was Stroud Pride, and so I think whilst the Supreme Court ruling is absolutely fabulous, and what the lesbian interveners did was brilliant, I think it'll take quite a long time to dribble down and to trickle down into to a local level, and I think perhaps sort of people who aren't same-sex attracted perhaps expect there to be a greater level of understanding than there is, but actually, I think a lot of lesbians, a lot of gay men, a lot of bisexuals aren't really paying attention in the same way as the general population aren't paying attention. So I think we've got quite a lot of work to do. I think when it's spelt out and when the consequences are made clear, just through one-to-one conversations, I think could be more important probably than any ruling in a way. So I think just opening up conversations is probably going to do more to shift things at a local sort of grassroots organising level.
Thank you. So I just want to talk a little bit about the local authorities and the public sector bodies that are caught really with the pants down, because they've disinvested in equality for 10, 15 years. And so they really struggle. They will really struggle now to get this right. So we've got a long time before we can. I'm over here. Sorry, we've got a long time before they can get it right. A, because they've got no money, and B, because they've disinvested for so long in understanding equalities, which is why they've got such a poor understanding of it. And I say that because I was at the Equality Human Rights Commission for 10 years. I now work partly for a local authority and partly for NHS, and they're in a mess, absolute mess. So the judgment is there, it's very clear, it was very clear beforehand. Getting them to do the right thing is going to take a lot longer, I think, than we recognise.
Yeah. Well, I think that's right, although I'm completely stumped about why it's not complicated. It really couldn't be less complicated than it is now. It certainly was very much more complicated 2 months ago than it is now. So I just don't understand why it's caused such a drama. Really, have a men's loo, a women's loo, and a mixed loo. Done. What's the problem?
Part of what Jo described as a tantrum response to the judgment is the kind of trans-industrial complex, claiming that this puts Britain at odds with international law, and they seem just so sure of that. And I can't see why, so I just wanted to know whether that is something we need to be worried about.
I can't see why either. I know why. I know. I mean, I understand the arguments that they make, but I don't think they're good arguments. They're arguing a number of different things. One is that one of the old cases from the European Court of Human Rights, Goodwin, means that somehow the UK has to provide some sort of means of self-ID, or at least certificated sex access to opposite-sex facilities and services, which isn't a great argument if you have read Goodwin and understand the parameters of that judgment, and also bear in mind that the UK, after Goodwin was decided, brought the Gender Recognition Act into force. And it was, part of complying with the judgment, or with the outcome of that and other cases in the ECHR, and that we also have the protected characteristic of gender reassignment in the Equality Act, which prevents people from being discriminated against on the basis of their trans status, broadly speaking, and it's very broad. But what we don't have is a right to incur or make incursions into other people's rights. And what the arguments that I've seen have signally failed to do is to acknowledge anybody else's rights at all. And I think that is where they will trip up if they get to the European cause, and how they're going to get there is also a complete and utter mystery to me, frankly. I mean, they seem to feel that they can just swan along to Strasbourg and knock on the door, and it just doesn't really work that way. But I mean, I may be proved wrong. It may be that the door swings open, but I'd be surprised. But yeah, I mean, there's a lot that's missing in the arguments that I've seen, and what's missing is a genuine engagement with the opposite, with the arguments on the other side, which is a feature and not a bug, and we've seen it in many other respects in this so-called debate. One of the things which has really characterised the trans activist side of the debate, in my experience, is of course initially the outright refusal to have a discussion at all for many years, and we saw that with no debate being the official position, and then an inability to do so as a result after that. And it just seems to me to be playing out now in the arguments which are being made in opposition to the judgment. And there's also a real kind of mishmash of arguments against the judgment, against the EHRC. I just, the focus, the target seems to be ever shifting. And I think they need to pick one. It's like either the judgment is wrong or the guidance is wrong. It can't really kind of be both, because they defeat each other if it's both. So, yeah, I'm not having sleepless nights over those arguments. The main reason is women have rights too, and under the Human Rights Convention in particular. So,
thank you very much for the talk. It was absolutely brilliant. In some of your earlier talks on the Supreme Court judgment, you've mentioned that protected groups can still meet and can meet as an individual protected characteristic or as several protected characteristics, as long as every member of the association has all of those protected characteristics. It strikes me that the forced teaming of LGBTQ, every other letter of the alphabet, is a mixture of two different protected characteristics, which not everyone has, and no protected characteristics at all. Does this have implications for various LGBTQIA groups?
Well, it does, yeah. I mean, I'm really very much giving you my personal legal analysis here, and I know that there is a variance of opinion on this, but because I'm always right, I don't understand why. I don't understand why there is, but it seems to me perfectly clear that you can have, when we're talking about associations, so an association is a group of 20, an organised group of 25 or more people where there's a sort of rules of admission and membership, and its members are chosen on the basis of criteria. So that's something like a large book group or a walking club or something like that. A women's rights network, if it's a membership organisation, I mean, LGBT Alliance, for instance, isn't, because it's not a membership organisation, but Women's Rights Network would be different. So it seems to me perfectly obvious on what we call a black letter reading of the law, which is just, looking at the statute and what does it say and what does it mean, that as long as the statute allows you to have a single protected characteristic group, so where everybody in the group has a single protected characteristic. It doesn't allow you to then include in that group somebody who doesn't have the protected characteristic. If you do that, then you're opening yourself up to complaints of discrimination by other people who haven't been let in because you've relaxed your criteria and you've made it random and arbitrary. Now, the reasoning holds if you have 2 or 3 or 4 protected characteristics, as long as everybody has them all. It just falls apart if you have 2 different protected characteristics, because then nobody has all, if it's, you can either be gay or you can be trans, then nobody in the group has all the protected characteristics, and certainly not everybody has all the protected characteristics. And there's nobody there's no basis on which you could argue this is a gay group or this is a trans group in order to defend yourself against discrimination claims from other people. I just don't see the reasoning for having associations where it's 2 alternative protected characteristics rather than 2 together. But that said, there are easy ways around it. So you can have an LGB group, that's one protected. Well, the protected characteristic is sexual orientation. So that would be, an LGB group arguably is one protected characteristic. Or if you had a lesbian group, that's 2 protected characteristics because it's women who have the protected characteristic of opposite sex attraction. And so on. But then you can have a separate group also for people who are trans, and then your 2 groups can do stuff together, and that's perfectly fine. But, as I say, people argue against this, and it's not been bottomed out yet. But yes, it does, in theory, have some implications for LGBTQ plus membership organisations, but I think they're easily overcome. I mean, I don't know anybody who wants to stop people from organising on that basis. The Equality Act is a little bit clunky in that respect. I certainly don't want to stop people organising if they want to into whatever associations they wish, as long as they're not unfairly excluding people, on grounds which are discriminatory. So, but I think that's easily done. In terms of services, it's a whole different sort of ball game, but it comes down to a pretty similar answer. So if you're offering a single-sex toilet to women, then it really does need to be women only. If you start letting in some men, then you can't defend a sex discrimination claim by another man who's been excluded on the basis that he's a man, because you've lost your designation as a single-sex service, and so you then can't discriminate against other men who want to come in. And there are various other discrimination claims that can come from that as well, like there are some that can come from women, but I won't bore on about those. So I think it's possibly less controversial now, but only just now, amazingly, that if you have a single-sex service, it really does need to be single-sex. But that does have implications for LGBTQ things like, well, obviously self-ID, toilets and so on, but also, club nights or park discos or whatever young people do these days. So, and that does have implications, but, a little bit of creative thought, and I'm sure it can be sorted out. It just needs people to accept what the law is and then think about how to work within it rather than just rail constantly against it, or alternatively pretend it doesn't exist. Because, I think we've come to the end of the road with that. At least I hope so. Although, actually...
If I'm holding the microphone, so I hope you don't mind if I kind of jump in. If you don't mind, I want to push back a little bit on a couple of things that you've said.
Sure.
You said that you feel like the judges are going to be basically kind of get us back to sanity. Mm. And I guess the question I have in this country is, if the judges are the ones that are going to get us there, how are all these people being sentenced to prison for mean tweets by these judges?
Oh, I'm not talking about the criminal law.
But okay,
I don't know anything about that. Don't blame me for that.
No, I'm not blaming it. It just I want you to be right. And the other question I have is, as you said, the young people are starting to push back, and I would argue the case that it's the young men that are doing this. It's not the young women. Yeah. The women are buying this hook, line, and sinker, and it's the men. It's actually the ones that aren't going to university that seem to be the ones that are questioning it and standing up.
All right, I get it. I think on the people being sentenced for tweets, I'm not a criminal lawyer. I don't really know the ins and outs of that, but I will say that sentencing is a case-by-case thing, and but I really can't give you an educated commentary on that. And in terms of whether it's young men or young women, I think it's very easy to generalise from an impression given on social media about that. I think it's not necessarily the case. I think there is obviously some sort of imbalance in terms of the sorts of political positions that young men and young women are taking, but I think it can be overstated.
Your Honour,
That's Your Excellency, thank you.
Yeah, all right, okay. We're not worthy. As an ageing pufter in the autumn of his years, I can tell you for the last 25 years, which I've spent wandering around Canal Street being an absolute awful person to most people, that I've been to just about every Sparkle Festival and every trans gathering that they put together. And without a shadow of a doubt, the vast majority of them are fetishistic and paraphilic men who are practicing their fetish in public without the consent of those around them. What does the letter look like to HR? Is the first question.
What does what?
What does the letter to HR look like when you've got one of these men doing this in the workplace, is the first question. And secondly, what do you think is the importance of shame in dealing with them?
Well, I'm going to leave your comment hanging on the latter point. And a letter to HR is a letter which sets out the facts. That's what you do. And if I know it is very, very difficult. If you consider somebody to be to have conducted themselves in a way which is sexually inappropriate and which is rooted in that sort of fetishistic behaviour, it's extremely difficult to get people to listen to you, because people will instinctively push back against that, in particular when it involves trans issues, like very, very much so. So you do, but making any serious allegation against anybody, you have to be sure of your facts. And the more serious it is, the more sure you really do need to be before you go to HR about it. But yeah, if you're sure of your facts, write them down, put it to HR, and let them to pick it up and deal with it.
I'll stick with shame, I think.
Yeah, the shame, I'll leave you to deal with the shame. I'm a lawyer. I'm not a shame merchant.
Thank you. Firstly, thank you both for coming up to Manchester. Really appreciate that and your time. Thank you very much. And thank you to the Women's Rights Network and the Free Speech Union for working together to put this on. It's pretty cool. Some amazing guests here. Thank you. My question is about the new data bill. The new data bill is going through Parliament in the UK. We know that you can change your sex/gender marker on your passport and driving licence really easily, which I think most members of the public don't realise. If these flawed data sets are used rather than the birth registry, is this self-ID by the back door, and how will this affect the EA10? Thank you.
Yeah, it's a really interesting one. I mean, it took me quite a long time to get interested in this, I have to say, because it sounds so boring. And Maya Forstater kept going on at me about it, and I was like, yeah. But actually, now I've read about it, I realise that it is actually a very important issue. The core difficulty, for people who don't know about it, the government are bringing in a digital ID system where, on your phone you can have an app, essentially, which is a government-approved app, which allows you to prove certain things about yourself, but without revealing other things. So if you're in a pub and you're 18, you can show just your age without having to reveal all the other information on your driving license, whatever. So maybe there's a creepy barman and you don't want him to see your address. You can just show you're 18, and so on. And it has all different fields which you can just show the relevant one. And the government are planning to sort of obtain the data which this system relies on from official sources. The trouble is, there is no official source of accurate data on biological sex. So the government are slightly all over the place on this. The thing that's closest to being reliable is the birth registry, not birth certificates, but the birth registry. But that only covers something like 85% of the population. So it doesn't cover people born abroad and born before a certain date, I think. So it's not complete, but it's the best. It's the next best thing. But driving license, so birth certificate can be changed with a gender recognition certificate, but driving license and passport can be changed on a self-ID basis, which people don't realise at all. A passport, you can just write to the passport office and say, I'm trans, and they'll change your passport for you, which is absolutely amazing. And there's no legislation which governs passports, sex on passports. It's all at the King's pleasure. So it's very, very weird. Sex Matters have been on and on at the government about making sure that the sex field in the digital ID service doesn't rely on these faulty data sets, and have had a lot of pushback from government because, you can see how if it does rely on faulty data sets, it will mean self-ID by the back door. I saw some parliamentary exchanges in which I think it was Chris Bryant was saying, well, people aren't going to need to be proving their sex anyway, so it doesn't really matter. And, just very strange things. But I think, my understanding is that there are more stirrings of interest in making sure that it's accurate now. And I think things are moving a little bit on that, although I'm not sure, who and why and how, but I think it is important. It's something to keep an eye on because, of course, this is one of the perennial questions when you talk about single-sex services. And people, make fun of, for instance, the EHRC guidance saying ask for a birth certificate because it's like, oh, who asks for a birth certificate at the door of the toilet? But of course, it's not about toilets. It's about rape crisis services and domestic violence shelters and places where it actually really does matter, and where you might be expected to be, entitled to ask for some ID. The brutal fact is that there is no ID. I mean, you can't access your birth registry records personally as an individual. So there is no ID that a person can produce which is reliable as to biological sex at all in this country, which it really does cause a problem for service providers. Now, that's something which needs to be dealt with. But if we replicate that problem within the digital ID service, then we're just making more problems down the line, for sure.
I was going to say, I think we've only got about 5 or so minutes.
Thank you. I'd like your opinions or thoughts around whether the recent judgments for clarifying the legal rights between sex and gender could be similarly used to challenge discrimination of sex rights in religious institutions or settings, particularly when we have a lot of religious, particularly Muslim politicians who are supporting hypocritically supporting self-ID in political environments and voting for all sorts of various actions, but wanting sex-based separation in religious institutions.
Yeah, well, it's a complicated question. But yeah, no, I mean, using the law to expose hypocrisy isn't necessarily the forum. I mean, the forum for exposing hypocrisy is more often than not the media or the political sphere. But, I'm sure that plenty of arguments could be made in respect of those sorts of arrangements. I mean, obviously the Equality Act does permit sex segregation, in particular in religious context. Well, not, I mean, it doesn't say explicitly, but it will take that into account, the fact that it's a religious context. But it's not a given, it's not an absolute rule. It's always got to be fact specific. So yeah, you may be able to use law to challenge those sorts of arrangements if they're not a proportionate means of achieving a legitimate aim. And you can try to expose some hypocrisy in that context of that argument. No, but it is interesting because you could say, look, because when you're trying to show that something is a proportionate means of achieving a legitimate aim, one of the things that you have to show is that it is a genuine attempt to achieve a particular aim, and that it is, actually aimed at that. And if you can show that the person doesn't genuinely want to achieve that, hasn't got any particular belief in achieving that aim, and it's not actually a thing that they're really trying to do, then yeah, that's your lever in. Hi.
Hi, I want to go back to judges and your comment about judges saving us. And I think quite a lot of people in this room were very surprised by what Lady Hale said last week about there's no such thing as biological sex. Now, I'm obviously not going to ask you to comment specifically about Lady Hale because that may not be a good way forward. But it would be really interesting to get a sense, because obviously we know about various lawyers and legal feminists, but actually to get a better sense of where the legal profession lies, if you are able to say that. How are things?
Yeah, well, I've been very disappointed, I have to say, in the aftermath of the judgment, because there's a bunch of us lawyers who have been working on sex and gender for years, and have developed expertise in it and understand the way. And it is complicated, it's not straightforward, but it's not impossible to get your head around it. In the immediate, and there are a huge swathe of other lawyers who just haven't touched it at all and wouldn't have touched it with a barge pole for years. And then as soon as we had the judgment and suddenly it became front page news, everybody started piling in with their sort of guidance for their clients, publishing it on the internet for guidance for their clients on how to implement the ruling, because they started smelling the money. And some of it was just atrocious. I mean, utterly, utterly atrocious, completely wrong, and would have led people down, and may well still lead people who are just trying to obey the law down a completely erroneous path. So that has been very, very disappointing to me. And there's also been a sort of rash of lawyers across the incredibly depressing LinkedIn who have been mithering about the judgment. Yeah, I mean, it's disappointing. But what I hope, putting my optimistic hat on, is that as people take their time, perhaps in a slightly more measured way, to actually acquaint themselves with what the law is, that we will have a burgeoning of expertise in this area. And I think overall, lawyers are probably more likely to be not, activists, not trans activists, than in other areas of life. Because, as I say, the law is quite sort of rational.
I think we've got time for one more question.
Hi. So just to reassure everyone in the room, young girls are very concerned about biological sex. I'm here with my 14-year-old daughter because she was insistent on coming with me this evening. So my other point is I work in secondary education, and it's a minefield. As a teacher who is gender critical, I don't believe or adhere to the gender ideology that's being put out there. Our children are being essentially asked questions that they're not ready to answer from a very young age. And for me, it's a case of, I see it day to day, how schools are very, very slow in adapting to this change that they're going to have to do. We have more and more unisex toilets because it's cheaper for them. It doesn't give girls the privacy, and boys as well. I mean, boys want privacy as well, but particularly girls, doesn't give them the privacy that they want to have. They are being asked to accept boys identifying as girls within their changing rooms. And also on a fortnightly basis, I'm asked to teach things, a subject called PSHE, which is kind of, like community stuff. Yeah. I haven't encountered it yet, but no doubt at some point I will be asked to teach about the gender ideology side of things, which I'm very uncomfortable in doing. So my point to you, I suppose, is, do you foresee there being much change very quickly? Is it within your remit of knowledge about education, secondary education in particular?
Well, the first thing I'll say is that the government have had the schools guidance in their court for some years and have not issued it. And the judgment of the Supreme Court has no impact whatsoever on secondary or primary schools, because it really is just about people with GRCs, and nobody under 18 has a GRC. So there, and furthermore, the Services Code of Practice, the Equality and Human Rights Act, the Equality and Human Rights Commission's Code of Practice, it has no impact on schools either, because it's not about education, it's about services. So there's no justification for anybody to wait around for anything before getting that schools of guidance out. And it should have been out long ago, in my personal view. And I think that schools are crying out for it. As I say, the judgment has no impact on it. I mean, it may inform the analysis, but in the sense that it's clarified a few underlying legal principles, but these are things which should have been clear to any half-decent lawyer long before the judgment was handed down. So I think pressure needs to continue to be put in relation to that, because it's a really, really serious issue. What's going on for young women who are having to nip out to McDonald's for the loo at lunchtime, or holding it in and getting cystitis and all the rest of it that you've mentioned. So I think that schools guidance, that it's something which is that campaigners might very usefully put their minds to and continue. I know lots of people campaign really hard in this area, but it is something which still needs an extra push.
Thank you.
Excellent. I think that's possibly all we have time for. So thank you so much, Akua, and thank you everyone for coming. Did you want to make a few remarks to?
Can I just say thank you very much for all your questions and for coming along? I'm extremely honoured.